you go up to the view open in the upper right hand corner
I did.
and click that and then go to
Speaker,
speaker.
thank you. Thank you everyone for your patience. We've had some technology issues. This is Sarah Mellish, Chair of the Zoning Board of Appeals. I'll call the Zoning Board of Appeals 40B meeting to order on Wednesday, August 3rd, 2022 at 4:16 p.m. I have with me in the room Jim Dietrich, who's an alternate, Brian Solacey, James Mitchell, myself, John Veneris, Sean Zahn, who's an alternate, and Catherine Howe, along with Town Council George Pucci, Town Administrator Greg Fetterspiel, and the clerk Gail Hunt. As a reminder, we will not be taking any public comment in this meeting. Be aware I can.
Yeah, just click that up there.
Unmute themselves. Okay. The purpose of today's meeting is to begin deliberations on the 40B comprehensive permit application of Jeffrey Engler of SLV School Street LLC. The goal of this meeting is to hopefully make a determination regarding whether we will deny the comprehensive permit or we will approve it with conditions, to look at the remaining waivers that we need to either approve or deny, and to hopefully come up with a general set of conditions that will enable town council to commence the draft of the decision. Okay. So do you want to look at the environmental waivers first, or talk about deny versus approve the conditions first?
I think we should discuss deny versus.
Okay, I agree. Okay. So if we deny the comprehensive permit, it's my understanding that we cannot include in the decision like all of the conditions that the applicant has agreed to. If we do approve with conditions, then we can get the conditions all that have been approved by the applicant, as well as other conditions in the decision. If he appeals, then the HAC will relook at all of the conditions, not necessarily just ones that we add to it. And the other thing is that he has to show it's more uneconomic than the existing project.
One of the questions I had for town council regarding the decision whether to approve the conditions, these waiver requests, or to deny the comprehensive permit entirely. What are the ramifications if we deny? My loose understanding at this point is if we deny, it will very likely be appealed.
Right.
And based on prior conversations with town council, besides taking a lot of time and costing the town a significant amount of money in legal fees, we would likely lose. And if we were to lose, which again is likely, my understanding is that all of this work, all of the conditions, all of the requirements we've added into, all the concessions the developer has made based on our requests would basically be thrown out the window, and he could build the project as originally intended. So if that's the case, in my view, denying it is kind of a de facto letting the developer do whatever he wants at some point down the road. And I don't think, unless I'm missing something, I don't think that's a proof course of action for us.
Right, that's what concerns me, but he would be controlled by the schematics he's providing to us. But one of my concerns is the ADA compliant sidewalk did not appear on the schematic, even though he agreed to do it.
I'm actually not sure.
Make sure you speak up.
I'm not,
The microphone's that white bar.
Hi, I'm not sure that we are likely to lose if we were to deny it. I don't know. That's actually something if we want to do a closed session, I don't know if we want to do it in this open meeting, but that's something I would take advice from council on, because I don't know that it's true with this particular project.
Well, that's why I posed the question.
Yes, Ms. Fucci.
Good afternoon, Madam Chair, members of the board. I'm George Pucci. Hopefully people can hear me. I don't know if they can see me. That's probably better. I'm off the edge here. Just to clarify and follow up to that, to your questions and both concerns that were raised. So the basic framework is, I always like to advise the board that you should really act on this permit application in accordance with your best sense of the substantial evidence in the record and how you think that you should act on it. You're acting as the local board with respect to local regulations like the wetlands regulations that you have. You should act on those in the shoes of the Conservation Commission. If you find that standards have not been met under those and that local needs, dictate denial of those waivers, then you should go ahead and do that and not worry so much about what may or may not happen on appeal. So the framework that I bring to it is exercise your jurisdiction over this project to the best of your ability based on substantial evidence in the record. However that comes out, we will defend on appeal. In the event of a denial of the permit, there will be an initial burden of proof that is on the applicant, that he will have to prove that. In the event of a denial, it takes an initial burden of proof away from the developer, so that the developer does not have to prove anything about project economics. In the event of an approval with conditions, the developer will first bear the burden of proof of proving that the conditions singly or in the aggregate render the project uneconomic. And then if he proves that, then the burden shifts to the board to justify by substantial evidence why local needs compel the issuance of those conditions. So there's a little bit of a difference in terms of the burden of proof at the HAC in terms of a denial versus an approval with conditions. The reason I always try to emphasize to the board that you should act on this application to the best of your ability. If you're far afield legally, I'll let you know. But you're a competent board. You bring different areas of expertise and knowledge of local concerns. You've heard the evidence. You have the ability to act on this permit. So that's what my focus would be if I were you. Let us deal with any potential appeal when and if that happens. So if you think that there's substantial evidence on the record to justify a denial of the permit, then you should discuss that. See if you reach consensus on that. Council will draft a draft denial decision. If you think that the better route is to look at it that it should be an approval with conditions with action on individual waiver requests, then if that's the consensus, I'll draft a draft comprehensive permit decision with that in mind. So, and in terms of what could happen on appeal, there most likely will be an appeal of any decision that you render. And if that happens, everything is off the table in terms of what the developer agreed to during this process. So in the event of an appeal, either an appeal of a denial or an appeal of an approval with conditions that the developer is unhappy with certain of the conditions that you oppose, or is unhappy with your denial or grant of waivers only to a certain extent that he's not fully satisfied with, he'll appeal everything. And I don't mean this personal to this developer. I just mean generally the way this works. When the developers end up before the HAC, everything is off the table that was before the board, and they're trying the whole thing anew. So anything they agreed to during that process is off the table. Anything that you think they might have agreed to, if they're happy with the decision, is also off the table.
But George, we're not building the record if we don't build in all of the conditions.
So that's
your appeal, right?
So that's a framework that you would want to look at. Some boards that have represented end up denying the permit and they issue a whole bunch of conditions, thinking that that will show the work that they did on it, or that on appeal, those conditions will be looked at and either affirmed or denied. It won't happen. In the event of a denial, you should just focus on the grounds for denial and do a denial decision. If you're focused on conditions that you want to see imposed on this project, then you want to have that dialogue. You want to see condition by condition, what conditions you would want to impose on this project, or you want to act on the waiver requests. And
Okay.
so the only way you'll have that analysis of conditions is in the event of an approval with conditions.
So let's go back to deny versus approval with conditions.
So I guess, my feeling is that based on the probably overwhelming amount of evidence from the Concom, from traffic and safety with respect to a second means of egress, those are two very huge issues that concern all the citizens. We haven't had any support whatsoever from the input, 700 letters, something like that. I would be leaning towards a denial, based on what George just said, that everything's going to be renegotiated after the fact. But I'm also willing to concede the consensus if you do decide to take the approvals with conditions on these waivers. We decide to add waivers. So I could go either way, but I would tell you that I do think there is significant and substantial evidence from the conservation, the vernal pools, the wildlife destruction, and the second need to egress issue. So on the safety side, I think there is reasonable and I'm not sure it's overwhelming, but I think it's substantial detriment to the town and to our decision making.
But we can also put those in as conditions.
We can.
Brian?
I couldn't articulate it any better than James did. I think that we have a situation where we're being asked to compromise the entire environmental ecosystem for 30, 40 affordable units. And the developer's trying to shove a square peg in a round hole. And I think that I understand both sides. And as James did say, I can go either way. But right now, my gut is that this is just a denial straight out, and let him try to, the 40B process is antiquated.
Doesn't matter, that's
No,
what's
my point
before
is-
us,
And
Brian.
my point is this, okay, is that when there was never concerns about environmental issues years ago,
Right,
okay, they are concerns now, okay? And I think we have to look at that. We have to look at public safety and the environment. And for that reason, I think that we were in good standing as far as denial goes.
well, my concern is on the public safety side. We did not have support from the fire chief for a second emergency egress. Police chief supports a second emergency egress for pedestrians, but we go further to support it for automobiles. So how does that impact your evidence with a lack of that support?
Well, we have been told that the police chief, excuse me, the fire chief doesn't have the final say, or he's only my opinion with regard to second means of egress. It's the question.
Kevin?
Answer your question, respond to your comments. I think it's overstating it a bit to say that the fire chief disagrees with the need for a second means of egress. I read his letter as being very limited in saying this complies with fire code. Not he thinks it's a good idea, not he thinks it's safe, not even he approves of the conceptual design. Just technically under the fire code, they comply.
It meets the
So
minimum.
I don't think, I guess I don't put as much, and then we have the police chief saying he would like to see a second means of pedestrian egress. Again, he's not condemning the whole project. I think those are important opinions, but I don't think they're determinative, and I don't think we should look at that as determinative.
The other point I'd like to make is that we've had several peer reviewers, the architectural peer review in particular, that said repeatedly that this project is too big and the site is too difficult. There are too many obstacles to overcome. So in terms of an economic hardship, I think that the developer is going to be hard pressed to make this a profitable project with all of our conditions.
Agreed.
And if it's too big and it's a bad site, or unsuitable, I should say, for this kind of massive housing development, I do think that's grounds for, again, that's another reason for denial.
We can't deny based on economics.
Okay, but I'm saying based on inappropriateness of the site and size of the project. If you look at context, if you look at detrimental to the neighborhood and the town, I think there's a strong argument in that regard.
I think,
I just need to, I'm sorry,
Go.
just getting a little bit of feedback from people who are listening. Make sure you speak a little slower and project to the speaker.
okay.
Sorry.
I have been considering this project very carefully, as I'm sure all of you have, over many months. And I had honestly started out thinking that this was probably going to be something that we would approve with a lot of conditions. But as we've gotten further along in this project, I cannot see how we can put enough conditions on this to make it a safe bet for the town. I am worried about the environmental damage. I'm worried about public safety. I'm worried about whether it fits into the town. Frankly, I'm worried about whether we trust our partner in this here. He's made a lot of statements. He's made a lot of carefully crafted statements, like when we were talking about his standing with AJC, and he said, go ahead and call and ask him if I'm allowed to work on this project. That's not really what we were asking, right? We were asking him about his overall standing. He made a lot of caveated comments, and I am not sure if we put conditions on. I don't have a level of trust that they're going to be honored in good faith. And so I think this could be a disaster for the town. Another concern that I have is that, as several members of the public and public commentators pointed out, and you pointed out as well, John, his financials may be significantly understated. And in that case, he could start the project and not be able to finish it. And we can't put it back together. Even if we have a performance bond with money, we can't put it back. So once this starts, it starts. And for all of those reasons, I am leaning towards denial. Then an approval with conditions, although I'm happy to talk about it and have my mind changed. I don't have a closed mind, but that's where I've landed after many months of thinking about it.
I think Kevin raised a good point that if we do approve this with conditions, the town and the code authorities need to make sure that all these conditions are being met. And when you have a town with one building inspector and one DPW, manager, how is that going to be all approved on?
Can I make one comment?
Yes, Sean.
What Ms. Pucci said is that, whatever conditions we put on there, he's more than likely going to appeal.
Right.
So they're no guarantee. And there's been a few things that he said along the way. One of them that really stuck out with me when we're going through the environmental, when they brought up about irrigation. And he was like, well, we'll drill a well. And I'm like, so, but we'll do that at a later time. So I'm like, he's going to add stuff in that's not even considered right now. So we've got to be consider that also. There's going to be changes as it goes on and the impacts that they're going to have.
Another comment is we talk about if we add conditions, he comes back and says, why it becomes.
Louder.
I'm sorry. I mumbled too.
No.
One of the issues with town council is that as we add conditions, he then can come back and say, well, now that makes the project uneconomical.
Right.
Okay, so we aren't talking economics there. Okay. And the reality here is the project is probably uneconomical anyway. Okay, so we add one condition and that tips the balance. He's playing really tight to the vest here. And this was, if it wasn't for the hammer of the state, this would never be done. This is a project that is no one would ever look at. Okay, and as I said earlier, for 30 units of affordable housing, it just doesn't work for this town.
Jim, do you have comments?
Let John talk again.
John, can I just add one thing on, just in follow-up to that about the economics, Sarah, if I can add this. There was a recent case from the state's highest court, and they upheld a concept that was recently adopted by the Housing Appeals Committee, that it's the developer's right to pursue a project that is uneconomic And that still gives the developer the right to challenge conditions that render the project more uneconomic. And I know that seems funny, but it's actual case law now from the state's highest court. They upheld the HAC's authority to impose that type of condition. So that may or may not be relevant to your discussion, but I did want you to know
Find
about
a
that.
place of common sense.
It's fairly hot off the presses.
The project costs have gone up, what, 20 million from the beginning? Will the mass housing finance relook at the financials before they give final approval, and they likely to change or not?
They will look at it before they grant final approval.
Yeah,
Whether that's likely to change, I would not venture a guess at this point. We need a lot more
Okay.
information about that.
because he provided us with a new pro forma with the costs are substantially higher, and then we have input on the public record that they're even perhaps understated.
Yeah, I just wanted the board to be aware that that is a standard that could get applied in an appeal, that he can go forward even if it's uneconomic. And if you make it more uneconomic, he has the ability to challenge it further. I mean, the policy, it seems funny, but the stated policy, at least from the state's highest court perspective, is that they want to encourage the building of affordable housing. So if a developer is willing to incur the risk of something that they can only get 4%, that's their right to do that. And that is consistent with the purpose of the statute.
But they also have to get finance.
Absolutely.
I have a question. for you.
Speak up, Catherine.
Yeah, Mr. Gucci, I have a question for you, and that is, if we deny this and it goes on appeal, and the applicant appeals this, what is the applicant's burden of proof on appeal for a denial?
It's your burden of proof
To show that the
to show
town.
that the denial is consistent with local needs,
Got it.
and that
Okay.
that those local needs outweigh the need for housing.
affordable housing. Got it. Okay.
So I mean, the thing is about that, and I know that there's heavy opposition to this project, but I've never rendered an opinion to this board about you'll win or lose at HAC or anything along those lines. So I just want to be clear about that. But there is something you do want to look at it realistically. The Housing Appeals Committee is set up typically in favor of developers. So I just want you to know that that is a difficult burden for a board to overcome. That, the compelling reasons for denial outweigh the need for housing. It's very difficult to overcome that burden. But that doesn't mean that I'm saying you'll win or lose or anything like that. We'll defend the denial decision in that event. And the thing is about it is, it's not that easy to defend an approval with conditions either, because it's still the same. I'm not saying that the Housing Appeals Committee does anything improper. They're a state agency charged with, pursuing the objectives of this statute, which is to build affordable housing. And that just is what it is. So both types of decisions are very difficult to defend on appeal. So if you're thinking, oh, I want to do a denial versus an approval with conditions or vice versa because of my chances of success at the HAC, you really shouldn't think that way. You should just put it more on, I'm a board member, I've received evidence, this is how I feel about this project, here's the substantial evidence that justifies the decision that I would like to see rendered in the case.
Something else, John?
Well, the local need that I see in this town is that we need quality, safe, affordable housing. And when you have 34 units restricted to 80% of AMI, that to me is not affordable housing. To me, affordable housing is rents restricted at 60% AMI, 50% AMI, 30% AMI. I see this as workforce housing, a small component of workforce housing, and then a larger market rate component. A project that is large scale on its own island. The kids can't walk safely to school. You need a car to do anything from this development. So I truly feel that the real local need for this town is real affordable housing, quality affordable housing, not housing that's off on some island somewhere on a site that is really undevelopable. I mean, if, all you have to do is look at the acquisition, the land acquisition is almost $5 million, but yet it appraises at $1.6 million. 15 acres appraising for $1.6 million in Manchester. That's unheard of. What that tells me is that the appraiser determines that site is really unbuildable. And that's where you have that difference between the actual land acquisition and the appraised value. So just, I guess, going back to local need again, we don't need a large market rate development that looks like a shopping mall. We need real affordable housing that blends in with the community. It's closer to downtown, close to public transportation, and those are just my thoughts just about the local need topic. Thank you.
So if we're going to deny it, what's our substantial evidence?
I think there's, well, I haven't spoken yet.
Oh, sorry, Jim, go ahead.
I've been listening to all this, and Catherine and John have presented some very good points. We do need more affordable housing, but this is not going to provide it for us. It's going to provide some affordable housing. It's going to provide housing where people will be nowhere near the center of the village. They will be driving everywhere. The site is a difficult at best site. I feel that we should deny it, and that some of the conditions for denial is it is not a good site to build this. It is not going to add to the benefit to the town or to any of the residents who live there. And we can probably develop an even longer list of issues for our denial. I'm sure we can.
I think my leaning towards a denial is based on the conservation concerns, the environmental concerns, and the aforementioned safety concerns. Also, just the inappropriateness of this large scale project. I believe the town needs affordable housing, but it's just not this. It's too much, it's too big, and the site is too difficult.
Can I just add, what really concerns me is the idea of having roughly 7% of the population in the town living off of one roadway, one driveway. Call it a road, call it a driveway, whatever you want to call it. That to me, in a single building, by the way.
Right next to the driveway.
Right next to the driveway. So, and I've seen it happen in my career before, where you finish constructing a building and then it just burns down. In my case, it's because the sensors outside didn't turn on and the entire building burned down. So what happens now if this happens here on off of a driveway that's a half-mile long, that winds, and it's got 30-foot retaining walls? I just think about that all the time. That for me, like, we can talk about vernal pools and, you know, wetlands and situations like that, you know, those are, for me, that gets very technical, but just looking at this from a common sense approach, I'm not comfortable with the idea of that many people living in one building off one little roadway like that. I'm just not.
Well, and I remember a few years ago, there was big new apartment complex
And
And the
PVD
Route
somewhere,
1,
yeah.
where you connect to 128 and somebody dropped a cigarette in the mulch and the whole building went down before the sprinkler system could engage. Because it was on the outside. And if it's next to the driveway, other people can.
The thing that's really bothered me about this entire project is the developer, when questioned on virtually any issue that's any controversial issue, has basically said, I don't care, the state will let me do whatever I want. Well, just because you can do something doesn't mean you should do something. And that's important because, as John has said, we're going to have a large percentage of the residents of the town living on an island, essentially. An island that is connected with an 1,800-foot driveway. In bad weather, that's going to be a real major issue. I think that there's just too many impracticabilities of this whole project that we should deny it, and we should very carefully structure our denial so that when it's appealed and the court listens to it, maybe they will pay attention. Yes.
Something else, Sean?
No, I mean, I'm in total agreement with everybody. I just, asking for so many variances just is a huge signal to me that this project is not that serious.
And I would also like to say something that has really bothered me since the last meeting is during Mr. Engler's, he gave a speech at one point and said something like, you know, you can do this and you can put a bunch of conditions on it and this is gonna be a great project, but if you don't, then I'm gonna win anyway, you're gonna have a worse building. Well, you know what, like that doesn't signal to me that he cares about this town, that he cares about what's good for the residents of this town or the building that he's creating. Threatening us with a worse building if we don't approve what he wants, that's not the kind of person I like to be in business with.
So can I just ask, and this might be a stupid question, but let's say this does go to appeal and the court's hearing this, don't they look back at those videos and see the threats and see how stuff goes down on some of these calls? And say, okay, well, you know, yeah, I mean, they are right, and that's.
John, you're talking about HAC reports.
Yeah.
So HAC is he would appeal to HAC and they would come down with a decision.
No, but someone has.
Then somebody, but then they can, no side copy, then you can go to the court system to appeal the HAC decision.
Okay, but
And
at
that's
some
a
point,
different-
isn't there a discovery period when someone is reviewing all the documentation and perhaps the meeting minutes? Or are they just making a decision?
Mr. Bucci?
Yeah, unfortunately, it doesn't go down quite as cleanly as you would think. If there are issues for, let me just back it up and describe how the process will work at HAC. So in the event of an appeal to the HAC, the hearing is de novo, which means all on new evidence. So it's not based on the record before the ZBA. Certainly, evidence that came before the ZBA will be part of those proceedings, but the HAC is not limited to the record of proceedings that was before the board. When those proceedings go ahead, the way that the cases are tried is they call it an administrative hearing. But what the parties do is they'll set up a schedule that the parties file pre-filed testimony, which is what an attorney would typically elicit from his or her witnesses on direct examination. So instead of doing that initial direct examination Q&A, you do it in the form of pre-filed testimony, which is like an affidavit. File that with the committee. Then the administrative hearing, which is like a trial with a stenographer, is limited to cross-examination of the other party's witnesses. So the only place where something like what you're talking about would come out would be, say, my cross-examination of the developer at the hearing.
Sure.
I can tell you the focus is heavily on the technical issues that were before the board.
Sure.
So when you get into, you know, I like to consider myself a good cross-examiner. So I do tend to have things in cross-examination that are interesting, you know, of credibility issues or anything like that. But I can tell you, it's not a free-for-all. They will limit it. They will limit you if you're kind of going afield of the issues that are before them. And then the last issue that you need to know about is the Housing Appeals Committee decision is also appealable to Superior Court. But that case will be limited to the record. So there will be no discovery or cross-examination in that proceeding.
Is that case limited to the record of the housing appeals decision, or is it limited to the record from here?
Correct. It'll be the state administrative agency's record.
Okay,
But remember, you're a party to the proceedings. So
Right.
any evidence that you want to be part of that record will come out during the HAC process.
And we can have expert witnesses as part of an appeal to the HAC.
You would have fact witnesses and expert witnesses, correct? And the only other thing I would mention is you gotta pay for your own witnesses at that point. The applicant is not paying for your expert witnesses, similar to the way they funded your peer reviewers.
Yeah, and just my overall point was just that, I want the appropriate authorities to understand what led us to our decision making. It's a culmination of the back and forth discussions we had over our calls, the review of due diligence, et cetera. And that was just my basis for that question.
I think it's valid too. I mean, the validity of,
Talk louder.
I'm sorry, I think the validity of that argument is good. This decision wasn't made in a vacuum. There were a number of factors, and it might have been minor, but it was a factor that led us to this decision. That's all
I think there are major factors. I wouldn't call any of these. If the burden of proof on the denial during the appeal process is on us, I think we have substantial evidence, peer review, expert testimony that will concur with our decision making and prove that we have reasonable demands here or reasonable assertions about what the impact will be to this town, and they're all negative. And so probably we've talked this to death. There's probably 3 different areas where we could.
So are we ready to take a vote?
Well, Sarah, I know you.
Yeah, what's your thought?
opinion? You're the chair, and we haven't really heard much from you. Other than
I mean, the way I was leaning is to approve with conditions so that we could establish the record containing all of the conditions and all of the conditions he'd agreed to. Because he agreed to a lot of conditions. And I don't want to lose those. That's my concern. But if there's a way of putting a lot of that into a denial decision, then I'm fine with it. I mean, we've got 2 pages worth of concessions he's made.
I have a question for council. If he has agreed to those, is he totally binding to those?
No,
So,
all bets are off on the appeal.
no, I mean, right now, is, if he could, that he agreed, if we do reduce conditions, does he already have to agree? Or since he can now appeal, walk him.
No, that's the issue, is that if he's unhappy with anything in there, he's gonna appeal, and all bets are off.
And the chances are we would put conditions in for, sounds like a second egress, sounds like an issue with vernal pools, so he's likely to appeal.
So my thought is that we put the whole thing in his lap, and that we have to have the whole thing's gotta be reapproved.
In other words, it's denial.
I don't know, that's right.
And I agree that it's important that he's made some concessions, that we have some agreement on some of these orders. But if the net result is that he just appeals it and everything gets thrown out, then I think we're better off and cleaner than just denying it outright.
I mean, HAC would go through every single condition you put in there and decide whether to uphold it or not,
But again, as
if it
Attorney
was with conditions.
Pucci has just advised us that everything's.
Yeah, but they're still gonna look at every condition you put in there. Well, they
Yes,
don't-
you would have the ability to defend those conditions. Again,
I don't think we can condition it. I honestly don't think that there's a way to, let's just take public safety that we were just talking about. Developers told us a million times a second road is not feasible. If we put a second road as a condition, he's gonna say it's uneconomic, and he might be right about that. And, so I don't think there's a way we can make the condition.
I'm sure it's right that it's not economic to have a second means of egress, but also. the way
Maybe
it's
you can make
point,
it
it's a
smaller.
site, is it appropriate?
I agree with you.
Because there's no easy way to
Right.
have a second means of egress.
I
So
agree.
it's kind of a
Kind of proves
circular
the point.
conversation.
Yeah,
But
proves
it's
the
just
point.
too big and not an appropriate piece of land.
So we want to take a vote?
I would be careful about taking a vote at this point, because it
Okay.
kind of, if you vote now to deny the permit.
Yeah.
Then you've got 15 days to file that decision. What I would recommend you do
Oh.
instead is if you think you have consensus,
Okay,
I would recommend maybe instructing council to do a draft denial decision. And then you would have a further deliberation that you would have, be able to act on that at
Okay,
that time.
are people in agreement with that?
So can I ask a question? So let's say we pursue that avenue. I assume we'll have like another meeting in 2 weeks or so, and then by then maybe you'll have something for us to review? Is that how it will play out?
So, yes, I would have that to you in advance of your deliberations. So you'd have a chance to look at it. You wouldn't be able to communicate as a quorum on it in advance of the meeting, but you would have it as individual members in advance of the deliberations so that you would be prepared to discuss it.
Yeah.
Sam, how you doing about that?
I'm fine with it. I mean,
You're the one that put all the rules.
well, it's difficult to know until you see a draft of the decision.
And then if we don't like the draft, we haven't painted ourselves in a corner.
Right,
No.
right. We
Well,
just,
not papers.
just using up time.
And money.
Well, we could say we don't like the decision to deny and go back to.
I think this is the more prudent course, because it gives us some flexibility to readapt.
Okay, yeah, that's fine. No, we're not gonna vote.
Make a motion.
Well, we're,
You don't even have to move to do that. I mean, I get the consensus of
Yeah.
when I take my instructions from the chair.
Right.
Her instructions to me are always, well, representing you very well. So if those are the instructions from her, I would have that to you in advance of your next session.
okay, so we'll move forward with the draft decision to deny. And it is August 3rd. When do you think the draft decision could be done, Mr. Kuchar?
I can have the draft decision to you by the 12th,
Okay,
Friday the 12th. Unless you're telling me you're not going to meet the week of the 15th.
well, we gotta talk about that.
But counting back, if you use that, the only thing I would want is, I'll take more time if your deliberations are further out from there. If your deliberations are the week of the 15th,
Yeah,
I would recommend I have that to you by close of business on the 12th.
okay, we gotta talk about that. So the week of the 15th, we have our normal monthly ZBA meeting on Wednesday, the 17th,
Yes.
with third
Wednesday.
Wednesday, with 4 things before us because we had to postpone July. So I don't think we can do the 40B in that meeting. So is there another day that week people can meet? Like Thursday?
Thursday. Let me check on Thursday, real quick. I might have to bring in another town, but I think Monday or Tuesday I can do. Let me check on Thursday.
And on Tuesday, I have, third Monday tied up.
Right,
And are we doing trees on the 18th?
No,
Okay, so I do have to.
we have the.
Need a date, I'll be there.
Tuesday, the 16th,
That's doable.
Mr. Bucci, is that doable?
That works for me, yeah.
Okay. What time do we want to meet?
A little later in the afternoon. That would,
Anytime works for me on that day.
What time are we thinking? In the evening, or usual time, or earlier?
Earlier? I don't know, what do people want? Do we want,
I'm around.
from 5 o'clock onwards.
okay. How about 6:30?
6 or 6:30 would be great.
6:30?
6:30.
Tuesday, August 16th. We will receive the draft on August 12th. So I will expect that people will read that draft prior to the meeting and come in prepared to discuss it, because I'm sure there'll be revisions to it. And so there'll need to be more time, and we have to conclude our decision no later than September 5th. Okay,
And we're here, right, same time? meeting in person, now we know how to work the screen.
We just gotta make sure the board's not loose.
Is that something you would like?
Okay, so is there anything else we need to discuss?
I'm still a little fuzzy on Mr. Fuji's comments about conditions and how conditions can be tossed out by the housing authority. So maybe you can address that again for my benefit. Maybe I'm the only one who's fuzzy on it, but it seems that if conditions can be basically discarded, then why bother? What's the point? Now, maybe I'm too practical and I'm not an attorney, but I'd like to feel comfortable with this saying, I'm in favor of denial right now, but I want to make sure I look at all the options, and I still feel a little fuzzy on that. And so if you could indulge me, I would appreciate it.
Yes, I'll try. I don't know if it will help. If you're not the first board member who's expressed that concern. I had a board a few years ago, and they were talking about an approval with conditions. They were substantially reducing a project, and they were imposing some very stringent conditions. And then a housing appeals committee came out on a different town, and that was an approval with conditions. And the housing appeals committee kind of went through each condition. They struck every single one. And so that member said, what the hell? Why don't we just deny? And I said, well, because then you have no chance to defend your conditions if you go to the HAC. And he was fine with that risk. And then the board ended up voting an approval of conditions. He voted against. He wanted to deny the project. So it is counterintuitive what can happen with these conditions. And the only thing I would say to you, the only thing that has legal certainty with regard to your question is if you deny it, the burden is immediately on the board to justify that local concerns, local needs outweigh the need for housing. There's no burden on the Ellen at all, except to prove that his project meets state and federal standards. Is basically a non-burden. So the burden goes to you. If you have a denial, you have no ability to defend any conditions that you might have wanted to impose. Some boards have recited a whole bunch of conditions. They do a denial decision as though it was an approval, and then at the end they deny it, thinking that the reviewing board will look at their conditions and pick and choose what they still want to impose. And it just doesn't work that way.
Yeah, but when you're justifying the reasons for the denial, you can include in that justification, I would think, all of the conditions
What
that
got
would
you
have
there?
been required.
What got you there?
Yeah. So I think that's kind of the opportunity is when you have to justify your denial.
You
can
do
bring
that in
everything.
your denial.
No, when you go to HAC, I think you do.
Well, you can do it. Your decision will describe how you got to where
Okay,
you are.
yeah.
And essentially, it's almost like a site plan review. The way what I'm hearing from the board is you're leaning toward denial. You don't want to just do a 2-page denial decision. You want to explain how you got there. And just like similar to a site plan review, say it's not as a bright site plan review, but site plan review that there's the possibility of a denial. Oftentimes the site plan review board will go through everything, they go through all the conditions, and in the end they say, you know what? We just still cannot condition this project in a way that satisfies X, Y, Z concerns, and therefore we're going to deny it. So in that case, they have set out all the potential conditions on an approval, and then they explain at the end why they simply cannot go ahead and grant the project, because even with all those conditions, they still can't satisfy 2 key elements, and therefore they're going to deny the project.
So then if we deny, and we state in our denial all the reasons for our denial, that will be taken under consideration by the board,
The committee,
the committee.
yes, we would have to defend that.
you will have to defend, we will have to defend that in
Yes.
front of the committee.
Yes.
Okay. So at least there'll be a hearing for those things.
Oh, absolutely. I mean, okay, the whole thing, you'll have to justify why you denied it.
Okay, I'm straight now. Thank you very much. I appreciate that.
I think at this point, I would rather defend the denial than defend the
Yes.
conditions. I think that's a more prudent approach at this moment. And we may change our minds as we go through the
Well, me too.
process.
No.
No pressure.
Anything else? Then I make a motion to adjourn.
I would formally continue your deliberations from that date and time certain, just so the public knows.
Even though it's not a public hearing.
Yes, it's a public meeting.
Yeah.
So you want to do it,
We
I
all-
would just recommend you do that. Just move formally, date and time, and if it's going to be hybrid the way this is, I would just specify that. Trust me, you want to be overly cautious in this.
Yeah.
So I move to, continue the deliberations on the 40B comprehensive permit with Jeffrey Engler of SLB School Street LLC to Tuesday, August 16th at 6:30 PM via hybrid meeting.
Second.
June 2nd. All in favor?
Yes.
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 I feel like doing roll call next week. Then I'll make a motion to adjourn. Second. All in favor?
Yeah.
Yes.
Thank you very much.
Thank you.
Thank you, people.